Hello friends, greetings of the day to all of you. We welcome you on behalf of NRI Legal Services. NRI Legal Services is a global firm handling property matters of NRIs. The property disputes of NRI and allied matters are handled in detail and meticulously by NRI Legal Services in India. We have been holding Ask Me Anything sessions in the past also and have covered a lot of topics. Today we are back with another session of Ask Me Anything, and in this session we'll be handling the issues relating to property disputes of NRIs and how to resolve those property disputes. We'll try to guide you on your disputes if you have any in India relating to your property. You are requested to ask questions from us. It would be our endeavor to answer all your queries so that your doubts are clarified, and it would be our endeavor to answer those in detail. Now during this session I will be assisted by my senior legal associate Ashi.
Hello everyone, this is Advocate Ashi Pawar, Senior Legal Associate at NRI Legal Services.
Okay. As I told you, during this session we'll be discussing about the property disputes of NRIs and how to resolve those property disputes. And what are these property disputes? These property disputes can be of many types, like disputes relating to ownership of the property, disputes relating to inheritance of the property. Disputes can also be between the landlord and the tenant relating to the property of the landlord. There can be disputes pertaining to between the buyer and the builder. There can be dispute between the co-owners of the property, and there can be dispute also regarding the illegal possession of the property. So all kinds of disputes arise relating to these property matters. We'll be handling those disputes in detail. I'll be throwing lights on such type of disputes which are there between the builders and buyers, between the landlord and the tenant, and so on. I'll throw light on that also. But how to resolve those property disputes, that we will also guide you. Now going ahead, if I say that the NRIs are generally not very well placed to handle their properties in India, being distant away from the properties. So how to overcome, how to handle their properties? Basically they can appoint caretakers, they can appoint trustworthy people to manage their properties. So management of property is the main concern that the NRIs should know, so that their property remains safe. Now coming to the dispute pertaining to the ownership of the property. Before we proceed with this type of disputes, and I throw light in between, if any question comes, Ashi, you
no
can,
questions yet, sir.
Whenever it comes you can just let me know.
Sure.
Right? Okay. I was talking about the ownership disputes. Regarding the ownership of the property. Now how this dispute arises? If an NRI buys a property and he has a registered sale deed with him, and it is seen that someone else also claims the property. How he is claiming the property? He is also having a registered sale deed with him. Now there are two owners of the same property. Then how to resolve that dispute regarding the ownership? Because there is a dual ownership over the property. Now this dispute can only be resolved by going to the police, initially filing a police complaint and approaching the police and requesting them to verify. And for that you should have the original sale deed with you, original conveyance deed, and only then police can assist you. And if the other person has fake documents or documents created by fraud, then the police can evict them from the property. Otherwise those people, if they don't possess any document, police can evict. If they have some document, then you are left with no choice but to approach the civil court by filing a suit for declaration and getting the sale deed declared null and void, which was subsequently registered by the present possessor of the property. Now going ahead, what should you do? How to resolve this dispute regarding the ownership, and be careful about that such property ownership is not disputed. So the main thing is that you should be careful that when you buy a property, you should have all the documents with you. You should ensure that the seller is genuine, and also you should ensure that the documents are in order and the property does not have any encumbrances over it. Then you can overcome such property dispute that is pertaining to the ownership of the property. Now I see
we have some questions,
there is
sir.
some question.
Let me read it for you, sir.
Okay.
We have a question from Sanchit Malik. Me and my father are residents of UK. My grandfather owned agricultural property near Jalandhar. He has passed away recently and we want his land to be transferred in the names of his children, but my uncles and aunts living in India are not cooperating. Also, my uncles have taken possession of the land. What is the best remedy to take the share in the property?
Okay. Thank you, Sanchit, for your question. Let me clarify to you that it is apparent and evident from your question that the property was owned by your grandfather, and after your grandfather, your father and the uncles have become the owner of the property. Now your uncles and aunts are not allowing your father to have the share which he is entitled to in the property. So the best way to resort this dispute is firstly try to do amicable settlement with them, and if they do not agree for the amicable settlement and they do not part away with your share, then you approach a court of law. You can file a suit for a declaration, a claim. Your father can file if he is alive, then he can approach the court father property given. So
Yes, sir.
a suit can be filed on behalf of your father in the court of law seeking declaration and possession, and also you can seek partition of the property to the extent of the share of your father. So this way this property dispute can be resolved, but it has to be either amicably or through the process of the court, as I told you. I
Yes,
hope
sir.
your query is answered. Thank you so much. Any other question?
Yes, sir. We have another question from Muskan Dhawan. I'm living abroad and I have a residential house in India. I rented 2 rooms of my property to a relative and made tenancy agreement with him. He never gives rent on time and has also entered into other rooms which were locked by me. What should I do? May I answer the question,
Okay,
sir?
please go ahead.
Thank you for your question, Muskan. You can file an eviction petition before the rent controller on the grounds that your relative, the tenant, has violated the terms and conditions of the tenancy agreement and has also taken illegal possession of the property which was not originally given under tenancy to him. So yes, on these grounds you can seek eviction of this relative of yours. Right, sir?
Okay, yes. I'll just add one thing.
Yes.
As you said that you had a tenancy agreement with the tenant, and now he has taken possession of additional property which is in the same complex, which is not authorized to do so. Now since you have a clear tenancy agreement with you which only authorizes the tenant to have certain possession in the property as per the tenancy agreement, you can also approach the police authorities and get those rooms vacated which have been illegally occupied by the tenant. But if he has any document showing his possession because of some other agreement which is made fakely, then in that case, as advised by Advocate Ashi, you can approach the court of law and file an eviction suit.
Yes.
Very rightly said, Ashi.
Thank you,
Any
sir.
other
Sir,
question?
next question is from Shalini Jaiswal. Hi, sir, ma'am. If the will is not registered, can property still be claimed on the basis of an unregistered will?
Okay.
Would you like to answer, sir?
Yes, let me see.
Yes, sir.
Shalini, thank you for your question first of all. Let me tell you that it is not mandatory to register a will. As per the Registration Act, the will, if it is not registered, even then it is considered to be valid. But it has to pass lot of tests before the court of law that it's a valid will. What are those tests? Those tests are that it has been made voluntarily. It was made by the person who was of sound mind. It was made by adult person, and also it has been duly signed by the testator, that is maker of the will, and also it is to be seen that this will has witnesses. If all those criteria are met, to prove the will, that it's a genuine will, it's a valid will, then you can always claim the property on the basis of an unregistered will. There should not be an issue. You can go ahead for claiming the property provided the will is genuine. I hope your query is answered. Any other question?
Yes, sir. We have a question from Rakshit Khanna. Hello, sir. I am very worried about my property in Uttarakhand. I appointed a caretaker in my house 20 years ago. He is living in my property rent free and I have never made any agreement with him. Previously, he never troubled me when I used to come to India. I even gave him money every time I visited my house. But now he has refused my family's entry in my house. He said he has become the owner on the basis of law of adverse possession. May I answer the question, sir?
Please. Go ahead.
Thank you for your question, Mr. Khanna. Your caretaker is twisting the facts in his favor. This is not the case. You are the owner of the property, has not become the owner of the property. You've mentioned in your question that you kept on visiting the property. So this means that you had clear interference in the possession of the caretaker. Secondly, you have mentioned that you had given him money. That means you have paid him towards his services. So the law of adverse possession does not apply here because it does not fulfill the basic requirements which are the possession must be hostile or it should be uninterrupted for the continuous period of 12 years and it should be peaceful. So in your case this is not the case and you can file a civil suit against this caretaker to take the possession back from this person and you will get the property back. Right, sir?
Yeah, very right, Rashid.
Yes,
very
sir.
well explained.
Thank
Okay,
you, sir.
any other?
Yes, sir. We have one more question from Sunil Kumar. Hello, sir and madam. I need to address my property issue. 4 years ago, I purchased a flat from a builder and as per the agreement, the possession was to be given within 3 years. I paid all the installments as per the payment schedule. After completion of 3 years, the builder said he wants more time to complete the project and asked for money because as per him the construction was still in progress and escalation of cost in raw materials. I am not willing to pay any extra money to the builder and he is saying that he will not deliver the possession of my flat until I pay additional money. The builder has already delayed the project by 1 year and now he is demanding more money. What should I do?
Okay. What's the name of the gentleman?
Sunil Kumar.
Okay. Thank you, Mr. Sunil, for your question. Let me guide you here. That you must be having an agreement to sell with the builder, as also brought out by you that the builder has failed to give the possession of the property which he was required to give within 3 years from the date of the agreement. Now it is evident that it's a clear-cut deficiency in service and you can always approach consumer court and you can seek the redress from the consumer court. There are two ways of seeking compensation from the consumer court. Either you can get the refund of your money along with the interest, or even you can claim the property back from the builder without paying any extra money. So far as the builder's contention is concerned, who is saying that this is the escalation in the cost of construction, that's why he is asking additional money. That is that does not seem to be a valid requirement of the builder, because the builders generally cater for such contingencies in their agreements, and once he has already catered and never mentioned that condition in the agreement to sell, so at this stage or at this juncture he cannot ask for additional money from you. So you can very well get the relief from the consumer court. And moreover, if the property is registered under RERA, then it is better you filed a case before the RERA authorities where you will get the speedy justice. I hope your query is answered. Any other question, Ashish?
Yes, sir. We have one question from Sameer Sam. Hey, my brother-in-law has done fraud on me by using the money I have sent him to purchase property in my name. He bought the property in his wife's name from my money. I have proofs that I sent him money. Please advise how can I recover the property from him. Let me answer the question,
Okay,
sir.
please go
Thank
ahead.
you for your question, Sameer. you can file a declaratory suit in the civil courts, claiming that you had paid the money towards this property, and your brother-in-law has done fraud with you, and for that purpose you should have all the proofs of the transactions you made in favor of your brother-in-law, and he used of that money he used to purchase the property, right? But if you do not want the property, if you want to recover the money from your brother-in-law, you can file a recovery suit, and in that case you will get the interest also on that money. And again, for that purpose, all the transaction proofs will be made record of the court case file, because we need to convince the judge as well that you paid the money but they bought the property in some other person's name, right, sir?
Yeah. So you have the option. Accordingly, you can proceed as
Yes.
advised by Advocate Ashi. Please go ahead. Any other question?
Yes, sir. One more question from Mohit Munjal. My father and my uncle had an oral family settlement regarding a joint land many years ago, maybe 30 years ago. My father was cultivating our land and my uncle was cultivating his land. Now, after my father's death, my uncle is trying to enter into our land. What should we do?
Thank you, Mohit, for your question. Now this is regarding that after the death of your father, your uncle is trying to enter into the share of your father.
Yes.
And first of all, let me tell you that your uncle cannot claim the property of your father or cannot enter into the share of your father unless it is clearly established that he has the ownership over the property. If he is trying to do so, you can always go to the court and seek injunction, and by filing an injunction suit against him, so that he is prohibited to enter into the property of your father. Secondly, in case that oral partition is not being accepted by anyone as on date, then you can always file a partition suit, so that in future such dispute never arises, and the property between your uncle and father is duly demarcated, and that dispute ends forever. So at the moment you can immediately seek injunction so that your uncle does not interfere in the property of your father, and also side by side you can go for a suit seeking partition of the property to end the dispute forever. Moreover, in case your uncle is willing and ready, you can even go for a family settlement now, which can be duly signed and registered by seeking partition of the properties through partition deed. That can also be done through the without going to the court. This partition deed has to be duly registered, so that all the dispute are come to end, and uncle does not interfere in the property at a later stage.
Right.
I hope things are clear. Any other
Yes,
question?
we have one more question. This is from Ignore Sandhu. My friend has given power of attorney to his brother in India to take care of his land. His brother is now trying to sell the property on the basis of GPA and never informed my friend. He is going to India to stop the sale. What other actions he should take? Let me answer the question, sir.
Please.
Hello, Ignore Sandhu. As a first step, your friend should revoke the GPA executed by him in favor of his brother, and give him a legal notice to intimate him regarding the revocation of the GPA. Secondly, he should approach the government revenue authorities and file an application over there stating that these properties are under the ownership of your friend, and if any application comes regarding the sale of these properties, those applications should not be entertained. Or he can seek injunction against your brother so that he can stop the sale of the properties. Right, sir?
That's right. Only thing, as I told in the beginning, that whenever you give power of attorney to a person, whether it is SPA or GPA, he should be a trusted person. He should be a faithful person to you, so that he cannot misuse such power of attorneys, as advised by Advocate Ashi. In case such inclination is seen on part of those people, it is better immediately revoke the power of attorney
without any delay. Right.
Yeah.
We have another question from Tejas Oberoi. Hello sir, my father wants to give me his property as I am his only child. We are not clear whether we should proceed with the gift deed or transfer deed or will. Please give suggestions.
Okay. Thank you, Tejas, for your question. Let me guide you here. That your father presently is willing to give the property to you as you brought out, but how he wants to manage his property, that is important. If he wants to keep the property during his lifetime with himself, then it is advisable that he makes a will. And as I told you earlier also, what all points should be taken care of while making a will. Will should be genuine and valid and preferably registered, and then during his lifetime he can manage the property, and in the will he can bequeath the property to you. Secondly, in case he wants to give the property to you during his lifetime, then the best option is to give the same to you through transfer deed or gift deed, depending upon the area of jurisdiction where you are staying, because certain places transfer deed is applicable and in some places gift deed is applicable. Through gift deed also, if the property is being given, then it is to be ensured that the gift deed is duly registered, and if it is duly registered, only then it will be considered to be valid gift deed. So the discretion lies with your father, how he wants to manage the property at the moment during his lifetime. Accordingly he can proceed ahead as advised. I hope it is clear. Any other question?
Yes, sir. We have one more question. It is from Thomas Sabarwal. I have a house in Ludhiana. As I am abroad, I put a caretaker in possession of the property 5 years ago. Now the caretaker has called his family also to live in my property. We have agreed that from now onwards he will live as a tenant. Can I execute the tenancy agreement with my caretaker?
Okay. It's a good move,
Yes.
I will say, because you cannot trust the caretakers to continue with the property, because subsequently they claim your property as the owner of the property if they continue to be possession for a longer time. Now it is good that the caretaker is entering into a tenancy agreement, and the tenancy agreement terms and conditions should be very clearly specified. He is treated as a tenant, and when you enter into a tenancy agreement, the terms of the tenancy agreement, like the rent which he has to pay, the duration of the rent, the duration of the tenancy, and whether there will be annual increase in the rent, and certain other terms and conditions like that. He cannot sublet the property, and he cannot cause any damage or cannot carry out renovation in the property. All those terms and conditions should be clearly specified, and under these circumstances you can keep him as a tenant. And the most important thing is that you should get this rent deed registered, and if it's a registered rent deed, then he can be evicted very easily from the property under the laws of the country, and by filing a case in the rent controller court, it would be easier to evict him. So you can go ahead with the tenancy agreement and take care of all these guidance which is given to you. Okay, any other question, Asha?
Yes, sir. We have one question from Shubham Sharma. Dear sir, I came to know recently that my Mama Ji has sold my mother's property in Gurgaon on the basis of general power of attorney. The general power of attorney is a false document, as it was executed in the year 2018, and my mother never visited India after 2016. She gave me this property in her will. Can I claim my mother's property back?
Okay. Thank you, Shubham, for your question. You have a very strong case,
Right.
because as clearly brought out by you, that your mother never visited in the year 2018, and after 2016 she has never visited India. So there is no question of giving GPA, and if your Mamaji is taking any action on the basis of GPA, it is evident that it's a fake GPA which has been created fraudulently by him. And as you said, that property has been given to you by your mother through will, so you can very well challenge if the Mamaji has transferred the property in his name. You can challenge that through court of law and claim the possession over the property, bringing out that this has been bequeathed to you as per the will. So you will have to, the genuineness of the will And secondly, you will also have to prove that your mother was not in India at the time of the execution of the will, for which the passports of your mother will also be required to show that she never visited India during that period. So under these circumstances, you can very well get back the property back from your Mamaji.
Yes.
I hope it is clear.
We have a question from Afreen Khan. Can you tell me how one can prove the ownership of Lal Lakir properties? My friend's father owned and lived in their house, which is situated under Lal Lakir, and after him his brother took possession of the same and is not giving him any share. They are two brothers and one sister. Can they prove that their father was the owner of the house? Let me answer the question, sir.
Okay.
Thank you for your question, Afreen. You must be aware that Lal Lakir properties are those properties which do not find mention in any of the government records, but the ownership of these properties can be proved on the basis of its possession. Okay, so your father's friend must have lived in this property, so his possession can be proved through various ways, like the water and electricity connection must be in his name, or the neighbors can acknowledge this fact that during his lifetime he has lived, possessed and owned this property. So your friends and your friend who are two brothers and one sister, they can file a suit against the person who is possessing the property, and they can easily prove the ownership and possession of your father on these basis. Right, sir?
Yeah, that's right.
Yes.
Now, to overcome these problems, the government of India has launched a scheme, and even the state governments also on the same basis have launched the schemes, wherein they are trying to get all the Lal Lakir properties registered,
Yes, sir.
so that the revenue records can be created. And once those revenue records are created and genuine owners' names are entered pertaining to those Lal Lakir properties, then in future such problem will not
Yes,
be there.
and lot
We are
of
hopeful
problems will be
that
solved, right, sir?
we are hopeful that such disputes then will go to civil courts, and you can claim your rightful share in the property on the basis of the succession or inheritance.
Yes, sir.
Okay.
Yes, sir. We have a question from Chiranjeev Kale.
Okay.
Good morning, sir. I am a resident of UK and I have a few properties in India. How can I protect my properties in my absence?
Okay. How to protect your properties in your absence? I have also commented earlier that you have to appoint a person who can take care of your properties. You should be a trustworthy person, who should be a reliable person, who should be a faithful person. And even you can appoint a caretaker, and caretaker should also have the same traits which I just told you, and he should give you regular updates. And you also need to visit the properties on off and on whenever required to ensure that these properties are safe, and also have liaison within your friend circle who can visit the properties regularly, and also keep giving you the feedback the properties are safe and secured. And if it's a property like you can say it's a plot or agricultural land, it is always advisable that there should be some fencing done on the property to secure the property. And
They can put a board as well,
even,
right?
yeah, that's what I was coming
Yeah.
to. Even a board can be put on the property showing that this property belongs to so and so, and trespassers will be prosecuted in case anybody tries to enter that property. So these are the various measures which you can adopt to secure your property in India since you are sitting abroad.
No more questions for now, sir.
Okay. Till the time we wait for the question, let me just throw light on some other property disputes which happen. Certain other property disputes also happen between the co-owners of the property who are having joint ownership. How that joint ownership or co-ownership comes? It is basically by way of natural succession. When the property is inherited by siblings from their father or forefathers, then they are generally the co-owners of the property. Now, during this co-ownership, it is evident that their share is not partitioned, because there is no will, there is nothing on that sort which can clearly bring out the share of the respective co-owner. So the dispute arises between the siblings that which part of the property will go to whom. So to resolve that dispute, it is always advisable firstly to sit amicably and sort out and resolve by an agreement which can be in the form of partition deed. And if your if all the parties do not agree to that partition deed opaque agreement, then the parties can always approach a court of law, and the respective co-owner can seek their share through the court of law. If the property is partitionable, then the court generally allows the partition in the manner to be allowed. Otherwise, the court can always get the property disposed of, and all the co-owners can be given the respective amount according to their shares in the property. And also it is seen that there are certain disputes arise because of the inheritance. When the property is inherited from the forefathers, it can be ancestral property, or it can be residential property or self-acquired property. Now, when ancestral property is inherited, again there can be a dispute pertaining to the share in the property, and partition can be sought of those shares if the share is not duly demarcated. And so far as self-acquired property is concerned, the self-acquired property can be either bequeathed through a will, which can be inherited on the basis of the will, or if the owner of the property does not make any will of the self-acquired property, then that property is divided amongst the all the class 1 legal heirs. Now, class 1 legal heirs, if have any dispute over the property, again it can be amicably settled, or it can be settled through the process of the court. Now, Ashi,
yes,
I think
we have a question, sir, from Rahul Thakur.
Okay.
Hello, NRI Legal Services. I am facing a problem regarding my flat situated in Zirakpur. I purchased the property in the year 2015 from a developer and logged this unfurnished flat in 2019 when I last visited India. 3 weeks back, I came to know that a family is residing in my flat and claims that they have purchased it from the developer. The developer is not communicating with me. What should I do? Can I answer the question,
Please
sir?
go ahead.
Thank you for your question, Rahul. As far as I understand your situation, you have been clearly defrauded by the developer, who has further sold your flat without disclosing the fact that you have already purchased the same. So, as an immediate step, you should approach the police officials and file a criminal complaint against this developer, so that the police can stop his illegal acts. And further, you must file a civil suit against this developer, and the subsequent buyers will also be made parties to the suit. All your title documents will be made part of this case, and you have to prove that you were the first buyer of this flat, and then the court will pass directions accordingly to the subsequent buyers to vacate the property and hand over you the peaceful possession of your flat. Right, sir?
Yeah, that's right. That's how you can get the property, because it is a very regular feature that by the sellers are selling the property to various people.
It's a very common dispute.
It's a very common dispute these days, rightly said. And if there is no question, then I would like to just conclude on this session. But I think there have been a lot of issues which are being faced by the NRIs, as we have seen, that the large number of property disputes which are occurring from day to day in India. And as I advised you, NRI Legal Services is here to render help and get those property disputes solved through amicably or by the court of law through the court process. And as I earlier said also, that in case you have your properties in India and you want to secure your properties properly, it is better that the properties are duly taken care of by the trusted people and reliable people. And in case you want to have your roots in India, it's advisable to secure the properties. If you want to get away from India forever, then it is better to sell those properties. Otherwise, as it is well known that NRIs are very easy targets, and being easy targets, their properties being unsecured, there are land mafia who are looking forward to grab those properties to ensure that such properties are not grabbed and are not made subject matter of a dispute, it is advisable to take care of them properly. So thank you so much for your questions, and it has been our endeavor to answer all the queries which have come to us, and in case any of the query has not been answered, we will address those queries separately and come back to you on that. And you can, those who have not been able to ask any query, you are requested to put your queries at query@nrilegalservices.com. you are welcome to clarify your doubts. We are here, my team is here to answer your queries, and thank you so much, and please take care of your good
Thank you
health.
so much.
Thank you, Ashi.
Thank you, sir.